Yes, good morning.
Good morning, Your Honor. May it please the Court, my name is Melissa Johnson. I'm an Assistant DA from Middlesex here on behalf of the Commonwealth. And I'm here today to ask the Court to reverse the order suppressing the evidence in this case. I'd like to start with the judge's findings here. And the judge's findings up until the point where he declares that the police in this case, the manner in which they conducted the search, was actually the Commonwealth has no issue with. The judge found that there was probable cause to arrest the defendant and conduct a search incident to the arrest, and even more importantly, he found that there was probable cause to search the defendant, probable cause to believe that there was drugs in a specific location located between his buttock cheeks. So there's those two findings. He also found that the search was justified in this case. However, the Commonwealth takes issue with the judge's finding as to the manner in which the police conducted the search in this case. And I'd like to draw the Court's attention to that additional layer of probable cause that we have here. Not just probable cause to arrest, but probable cause to search in this case, because that really drives the manner in which the police conducted the search in this case. In this case, as I said, the judge found that there was probable cause to believe that packaged narcotics were located in a specific location between the suspect's, the defendant's buttock cheeks.
So your position is it was reasonable for the police to search, to go, I don't know quite how to put it, into this person's body cavity?
No, absolutely not, Your Honor. Not at that point, Your Honor. We are not contending. And in fact, the judge found that there was no body cavity search. The judge found that there...
You say in your findings, you actually, in your brief, kind of go around a finding that may be significant here, and that was that he was found, the defendant, with his buttocks exposed, lying face down, cuffed on the street in public. And your discussion, however, really focuses only on another aspect where, at an earlier point, there was maybe pulling back of the shorts and unclear how far the reaching was, but reaching in to grab the bag of contraband.
Yes.
So is that an important distinction to you, and what do you do about the fact that, or is it important that he might have been exposed, his buttocks might have been exposed in connection with retrieving the drugs? That is, in order to retrieve them, they actually had to pull them down and pull them out.
Well, that's an interesting point that you raise, Your Honor. Do I think it's important? Yes, of course, I think the judge's factual findings are important, but I think it's important...
Now, significant to the analysis of whether it's appropriate.
Yes, Your Honor, because it's really a continuum. This intrusion that was happening here was a continuum for what was happening before the defendant decided to clock the officer in the stomach and try to flee, and what was done afterwards. The officer's actions have to be judged as far as what was appropriate before and what was appropriate afterwards.
It's the afterwards that we're on.
Is the afterwards.
Is it the afterwards or the before? I thought he pulled the waistband out before.
Yes, and it's interesting, Your Honor, just talking about these factual findings, afterwards the officer and the judge found that the officer, the detective, actually reached in and grabbed this particular item and immediately tossed it to the side. He does credit the father's testimony that the buttocks were exposed, contrary to the officer's testimony that his shorts were on the whole time. Not a lot I can do about that. I'm usually on the other side of the equation. So that is a factual
finding. You've got to take it.
However, what's interesting about that finding is that the judge never makes an explicit finding as to who actually pulled down the shorts, because he makes a finding that the defendant, even handcuffed, was trying to reach down and either grab the drugs or place the drugs up his anal cavity, according to the officer, what was going on underneath the shorts. So the judge makes that finding. He also makes the finding that the officer reached in and tossed the drugs to the side. So at the time that happened, it seems to imply that the shorts were still on. Yes, perhaps at the time that the father came upon the scene, the shorts may have been down, but we don't know, and a reasonable inference can be drawn that it may have been the defendant who was pushing the shorts down rather than the officer. We don't know. The judge didn't make that
Now,
finding.
if I can walk you through this a little bit. He stopped, they go to some area which the judge describes as secluded, and I gather, what's he wearing, by the way? He's wearing sweatpants, or what's he wearing?
He's wearing gym shorts, a leather jacket, and a fedora.
Okay, so he's wearing only gym shorts, so he basically
Yes.
pulls, do we know whether or not the buttocks were exposed in this secluded area? I mean, do we know how secluded it was?
The officer testified that they were originally on a sidewalk. He took them to a side of a house, and I have pictures in my appendix that were submitted into evidence, so you can judge for yourself. He took him to the side of the house because he didn't want anyone else to see, and then he pulled back. So I think of the gym shorts. So I think the inference could be that only the officer could see the top part of the buttocks. And both officers actually testified that there were 3 other officers at the scene, but they were all on the sidewalk or in the street, and
Now-
they don't even recall seeing what happened.
Now, just to make sure I understand your position, if the officer had not taken him to this so-called secluded area and had merely pulled down his shorts on the sidewalk to expose his privates and then grabbed it, would you concede that that would be an inappropriate and an illegal search?
I think it would depend on if there were other exigent circumstances at the time, but I certainly think that's more inappropriate than what was done here.
So how important is the exigency based on the defendant's assaulting the officer in the secluded area when he was about to grab the baggie?
I think it's important, Your Honor, for what happened later on. Certainly what happened later on, and what I was talking about before, that intrusion later on, the second one, seems a little bit more involved than the first one, but it's commensurate with what was going on in terms of the exigency.
But what's the exigency? He's cuffed by this point, and there are 4 police officers standing around him.
That's
So
a great
he's
point,
not going
Your
to go
Honor.
anywhere.
Well, he's not going to go anywhere, but he's still reaching down his shorts.
What's he going to do with it?
He's either going to push it further up his anal cavity or somehow toss it to the side. And I'm glad that you brought up this point, because the whole idea of the exigency here, and the judge specifically finds, well, the exigency could justify the situation here. However, he finds that there was no exigency. And I find that, and the Commonwealth submits that that's wrong, both legally and factually. And the reason is this. Legally speaking here, this is a probable cause to search, not just a search incident to an arrest. He has probable cause to search. That was found by the judge. And when you have probable cause to search and exigency, here the judge was saying, well, there was no weapon involved, and therefore there was no exigency. But when you have a probable cause to search, you must also consider the loss or destruction of evidence. And the judge never considered that here.
Well, exactly how is it going to get lost or destroyed?
But is that something that the officer needs to contemplate? So does he need to contemplate that when the defendant is reaching down into his pants and trying to either place it up his anal cavity or toss it somewhere?
So that's a win-win situation for the Commonwealth. If he forces it up his anal cavity, they can later do a body cavity search. If he throws it to the side, the defendant's done their work, done the police's work for them.
Well, I have a couple things to say about that, Your Honor. The first of it is that this defendant, from the minute that the officer spotted him, Officer Beelan spotted him in the car, to beyond the time that he was handcuffed, was trying to conceal the drugs in front of the officers in that location. So in that sense, he had to have known that the officers were going to and had reason and were justified, as the judge found, were justified in obtaining those drugs. The question is the manner. And this is my response to your question is, the judge finds, as your question implies, that the officers could have done something differently here. They could have had the 4 officers somehow contain him and done it later on, or done a body cavity search. So the alternative here is to have 4 officers constraining him on the ground, the drugs are still on him, preventing him from putting it up his anal cavity or tossing him for 10 or 15 minutes until that transport wagon comes, and then getting him in the transport wagon. He's still not under control at this point, then finally getting him to the private room that the judge says should have happened, where they ask him, they order him to remove his clothes one by one, or worse, if he succeeds in getting those drugs up his anal cavity, doing a body cavity search, which the judge said would have been reasonable given the circumstances in this case. Is that less intrusive and less humiliating
there
than
are
what
acts-
happened
yes.
here?
Answer, yes.
Let me ask you this question. If everything else was exactly the same except the sex of the defendant, would you say it'd be the same? Does the Commonwealth have the same position if the defendant was a woman?
If the defendant was a woman. Your Honor, I think that those are some of the factors that Thomas talks about. Is the manner of the search reasonable? Perhaps if it was a woman, it would have been less if it was different genders, and that would have been one of the factors this court could have considered. I can't answer that question just not knowing the other circumstances of the case and whether there are different additional exigencies.
The counsel doesn't, if this were akin to a strip search, or if we put it in that box, what you get is a second layer of probable cause reasonableness determination, which we're skipping over by not calling it what it is. I mean, you know, all those factors, is it reasonable, required in the circumstances, how much, what do we, you know, specifically, is it reasonable to conduct the type of search?
Yes.
All those factors would go into it. If you add that extra layer of, probable cause to search, but how about probable cause to expose someone or reach into their body cavities? Shouldn't that require some extra scrutiny, another layer of probable cause?
And a body cavity search does require a high degree of probable cause.
Not
That's
that high, but I'm talking about the
what
plain
happened
old
here.
exposing someone, making them naked. Or parts.
That if you make them naked, yes, that is a strip search, which does require probable cause to believe that that item could not be discovered but for discarding all of the clothing. So yes, you're right. It's a specific kind of probable cause. But I want to go to you were talking about the definition of a strip search or whether this falls into a category, and it's an interesting question here. The judge here, and this is, I believe, what drives some of the analysis here, defines this, creates a whole definition that's not supported by Massachusetts case law as to what a strip search is defined as. And I have a couple of issues with that. And the first one is that he talks about, it's not really removing all of the clothing, as we said in Prophet and Thomas. It's really just removing a layer of clothing that covers a particular body part. And I have an issue with the idea, or an intimate body part, and I have an issue with the word intimate because we have a whole population of youngsters here which basically believes that the top half of the buttocks is not an intimate body part. So that has to be somewhat refined as to what our common goals are, as to what can be exposed and what cannot be exposed. And the second issue, and this is even more important here, is that the judge can't simply tweak the definition of what a strip search is without modifying his expectations of what is considered reasonable for that officer to effectuate a strip search. And what I mean by that is, you take the case of Thomas, and this court had used the definition, a search of a naked individual without any scrutiny of body cavities. That's the definition. And this court said, you know, we suggest that you should do that in a private room. Well, that makes sense. We're talking about a naked person. And in this court, and this court's decision in Prophet, this court talked about discarding all of the clothing, the last layer of clothing. That case was a windowless transport van. Well, that makes sense. The person's going to be removing all their clothing. But here, if we say, okay, just simply retracting a piece of clothing where the only person that can see it is the officer looking at the top of the buttocks, if we're going to say, well, that's it, that's
Well, I would sort of agree with you, but then we have the fact that the pants are pulled apparently all the way down, or am I just misunderstanding that?
No, I believe that that was the finding, ultimately, of the judge. And as I had said before, we're not sure if that was caused by the defendant or the officer in this case. And I could see that my time is almost up here. Does the court wish to entertain any discussion about the policy in this case? If there are no further questions, I would simply ask this court to reverse the order of suppression here, and I rely on my brief for the remainder of my arguments. Thank you.
Thank you.
May it please the court, good morning, Your Honors. I'm Peter Onick for Carlos Morales. Your Honors, the case law that underlies this issue, Thomas and Profet, makes very, very clear that no one other than the investigating officer should see the naked body part of the suspect.
So do you concede, then, that the arresting officer here, who took the defendant to a secluded area and pulled back the shorts, where he certainly had probable cause to believe that the defendant was hiding contraband in his buttocks, that would be fine?
No, Your Honor. I believe that was a strip search as well.
Really?
That was also intrusive.
Well, it may have been intrusive, but a strip search?
Yes,
Pulling
Your Honor.
back shorts. We're not talking about undershorts. We're talking about gym shorts, to where the pat search had indicated and the defendant's conduct had indicated he was trying to get something up there to conceal it, maybe to dispose of it.
I believe the police needed a warrant, and authorization from a commanding officer,
Just
Remember
to pull
the-
back the pants or to pull them down, or both?
even to pull them back. But I don't think we need to dwell there, because what in fact eventually happened was that Mr. Morales was on the sidewalk, handcuffed, surrounded by 4 officers, and his pants were down around his legs. And whether or not the earlier observation by the officer was or was not a strip search, I don't think is critical here, although I believe even there, the judge was troubled by that, but he said even more intrusive was the fact that his pants were pulled down around his legs.
Now, what is the consequence of the fact that your client felt so strongly about concealing it that he ran from the officer when he was looking down his shorts in the woods and assaulted him, and then even when he was on the ground when cuffed, was, according to the judge, was still reaching down his shorts even while cuffed?
The consequence, Your Honor, is that Mr. Morales should have been arrested for resisting arrest. I believe he was. I believe he has a charge of resisting arrest.
But are you saying we treat that the same as a person who did none of that and is simply being arrested and the police want to do a more intimate search?
Your Honor, I don't think there's much of a connection. He, in the midst of this searching, which escalated to this total nudity on the sidewalk, in the midst of that, there was a fracas, and they exchanged punches or elbows or whatever. Mr. Morales, I believe, was arrested for that and faces charges for that. Why that becomes a justification for bearing his private parts, I do not.
Doesn't that go to the intensity of his desire to conceal, and isn't that something which may be considered in evaluating the exigency?
Your Honor, the officer had already felt the lump. I think he knew what it was. It was a single baggie of heroin. He knew what he felt. He knew, and that's what he wanted to retrieve. In fact, the judge finds that there was no question that the officer thought it was a weapon or anything like that.
And would it matter in your view if it were?
Well, a weapon, I think, always changes the calculus, sure, because there's danger, there's immediate danger to officers or the public. But that was not in any way in question. The officer had already felt the lump. He knew what he was after.
Well, it was, correct me if I'm remembering this wrong, but didn't the judge actually find that the pulling back of the pants was permissible? It was the all the way off. And I guess I raised that because by the time the pulling back the pants, he had seen that bag of drugs, hadn't he, the officer?
I believe, yes.
It wasn't
yes,
just
yes.
feeling it.
Yes,
He
did
had
say,
seen it.
Yes, and he called out, he's hiding it in his unmentionable. He called out to his fellow officer. So he knew it was between Mr. Morales' buttocks or even perhaps inserted somewhat, but certainly there and visible.
But I take it part of your argument is, to go back to something Justice Spina said, that it's you're weighing exigency against the intrusion and humiliation, et cetera. And because he's handcuffed and there are 4 police officers around, the likelihood that something, this bag of drugs is going to disappear and be unavailable is slim to none, isn't it?
I think so, Your Honor. Where's the bag going to go? This is 4-1. He's outnumbered. He's on his face with his hands behind his back. The judge addressed this. The judge said, well, they could have in some way restrained his hands, just assign one of the 4 officers to just stand there and hold his hands for a minute or 2 or 10, whatever it took. By the way, there were police cars there. They could have, he was arrestable, of course, right then and there on any number of grounds, for the drugs, for the resisting arrest, for the fighting, whatever. They could have placed him in a police car and taken him to the police station. Why were they waiting? They didn't need a wagon. At that point, he was going to be arrested anyway. They didn't need, as in Perfett, they brought a wagon to the scene and the private searching occurred in the windowless van or wagon. Here, he's being arrested. He's going to the station. Take him to the station. Why wait? Restrain his hands for a moment if there's a great concern that these 4 officers can't protect that little baggie of contraband for a few minutes. But take him to the station.
Just, this is a factual question, but, and I haven't looked at the photographs, I'm sorry to say, but it sounded from the judge's findings that the more secluded area, if that's his phrase, but it's still a city street because he was on the sidewalk.
It was by the side between 2 houses. It's, I don't have the image right in my mind, but it was by some houses, but off the main pathway of the sidewalk.
But it was a sidewalk. Is that right?
I believe it was.
Because he says he was lying
Oh, yes.
face down on the sidewalk.
No, he ends up, after the fracas, they sort of move, the locust moves back onto the sidewalk, and then passers-by, including Mr. Morales' own father, this was right near his home, passed by and saw him. I believe the father definitely testified, and the judge found that he was naked in his midsection, and the father saw it.
Counsel, I know Prophet and Thomas, of course, have the definition of what constitutes a strip search, and those seem to come from cases where part of the concept of strip search is the humiliation factor of having someone stand in a room and take off by order, one by one, all of their clothing so that they're standing there naked. That's a humiliating process, not just a result. If we were to not depart from that definition, how much are you relying on the fact that the department here had procedures in place and that these were violative of their own procedures to conduct this kind of search?
I think that's very important, Your Honor. And of course, it's not dispositive. The Lowell Police Department's protocol doesn't set the constitutional minimum, as the judge said. It doesn't tell us what the proper standard should be. But it's important to know what the Lowell Police Department, which does this work, thinks is the proper standard. And these officers did violate the protocol of their own department, which says you need a commanding officer to authorize what the police did here, and you need a warrant, and it has to be absolutely out of sight of anyone other than the investigating
And they
officer.
define it as impermissible, as something that rearranges clothing?
Yes, and I think that's a good question, Your Honor, and let me just point that out more specifically. I think it is very interesting, as we discuss, what is a strip search, actually, that the Lowell Police Department's own definition is the removal or rearrangement of some or all of the arrested person's clothing so as to permit a visual inspection of
So are you suggesting we adopt that? Is that what you're suggesting? I mean, the fact that the Lowell Police Department has got procedures that are trying to alert officers to a way that they think is best certainly doesn't suggest that that's required.
No, of course not. As I said, no, that doesn't bind us in any way. But it's interesting to know what they, who have to do this work every day in their practical work, think is a reasonable thing. And the judge took it in that spirit. He didn't say he was bound by the Lowell Protocol. He said, even putting aside the protocol, he said, I want to know what the protocol says. It's interesting. I think it's reasonable, in fact, and I'm weighing it. But even putting that aside, Profet and Thomas tell us what is the proper answer here. But I do commend the Lowell definition in the sense that it says some or all. And the judge, I think, also implicitly adopted that. The judge said it doesn't make sense to require a complete naked body when we talk about a strip search if they're just looking at the midsection. That is, if the person has one sock left on his foot, it's not a strip search. Of course it's a strip search. It's the last layer of clothing removed from the particular area that's under scrutiny.
Any area? Your gloves?
No, you're right.
Your shoes?
No, it's, I think the Lowell Protocol pretty well sets it out, permitting a visual inspection of the breast, buttocks, anus, or genitalia. I think that pretty well covers the areas that our jurisprudence would call those sensitive areas that should not be exposed to the public. The same areas, I suppose, that we speak of all the time in discussing indecent assault and battery. In our society, we consider those.
So explain to me how the pulling back of the waistband by the investigating officer in a secluded area is exposure of those areas to the public.
A strip search does not mean necessarily exposure to the public, Your Honor. The exposure to the public here exacerbated it. The judge here said that he was...
I'm talking before the scuffle and
Yes,
the pants got pulled down. I'm talking about the officer acting as he did to move him over, to move his waistband back to check to see what that lump was.
Now, the judge found that even somewhat troubling.
No, I know he did.
Because then he said even more intrusive was the baring of the buttocks and the lowering of the pants. So the judge was concerned even because, well, the Lowell Protocol says rearrangement of some or all of the clothing so as to permit visual inspection. That's a strip search. And strip searches require certain procedural safeguards, like the commanding officer's command and procuring a warrant and so forth. So that is a strip search. What implicit in your question is the question: what short of that could this officer have done in the practical reality there on the street?
Exactly,
and I think the answer is: look, he knows what he has. He's reached under. He's felt the lump. He knows what this is. This is Detective Damaris of the Lowell Police Department. He's done this hundreds of times. He could have, without necessarily looking in, he could have just reached in and taken out what's there. For instance.
Oh, I'm sorry. He could have, if he didn't look, he could have reached down and taken the bag.
Let us say, well...
That would be okay? That would be not a strip search?
I take your point, Your Honor. But this is not the focus here. The focus is what happened minutes later on the street with the buttocks bared, which I think, I would hope we could all agree is just almost in the realm of the bizarre. A man in broad daylight lying naked on the street surrounded by 4 officers. It shouldn't happen. It just shouldn't happen. And that's what the judge, I think, was really reacting to. Did the judge overreact to the pulling back of the elastic and so forth? Strictly speaking, the officer was violating his own protocol. Is the protocol too extreme, too protective of defendants? Is the Lowell Police being too protective of defendants in its protocol? I suppose one could seek to make that argument.
Right, but
would it matter?
I think, excuse me, Your Honor, I think it's admirable. Here's a police department faced with tough practical problems every day on the street, and they're actually making a conscientious effort to grapple with this and to say, you know what, we want a good standard of decorum here. And they set it pretty high. They set the standard pretty high.
Would it have mattered if no member of the public had been in the area?
It would not matter because it's the opportunity to be seen. It happens. People passed, and sure enough, the reason we want a policy that says you shouldn't have defendants naked on the street is because of the possibility that someone will pass and see it. Obviously, out of 100 cases, in some, nobody will happen to pass, and then in some, people will happen to pass. It's the opportunity. And of course, it's very humiliating to the defendant, Your Honor, whether or not someone is passing. And I don't even know if Mr. Morales realized that his father was passing. But how humiliating. And the judge cites a U.S. Circuit decision that gives the language that Perfett and Thomas use. This is humiliating, terrifying, frightening. You read it in the judge's decision, like a tally of 6 adjectives of how traumatizing this is. And it would be traumatizing to Mr. Morales whether or not he realized people were passing or whatever.
I can certainly see how pulling someone's pants down on a public street would certainly include all of those things. But here the defendant is trying to cram this up his rear, and the officer taking some reasonable steps to prevent that and to get that out of there, with the pulling of the waistband back and the reaching down and taking it, doesn't seem to create the same level of humiliation and all of the things we're trying to protect people. And I know that's not vital to your case because you're looking at the end result, but it just seems to me that there is a significant and important distinction.
There was the fact that Mr. Morales was reaching into his pants himself, Your Honor. Is that?
Well, yeah, the fact that that's where he was, in any event.
We
don't need to answer the question.
We don't really know why he was reaching into his pants. Maybe he was in pain. Maybe he was, he was reaching into his pants. I don't know why he was reaching into If I may just read to
Counsel,
you.
Your time is
Oh,
up.
okay.
Thank you.
Thank you very much.